Welcome to Pretty Lies and Alibis. Let's seek the truth and travel the long road to justice together. What you know, Alibiers, welcome to another episode of Pretty Lies and Alibis. I'm Gigi. Good to have you here on this Saturday. I wanted to get in these Khberger filings. They're pretty long. We're going to sort of condense them down a bit and go through those. And then we're going to update real quick on George Wagner, who we followed that trial last year. There's some updates in his case. But first and foremost, big thank you to everybody who's bought t-shirts, cups, merch, stickers, all kinds of goodies in there. I appreciate it. 10% off to the end of the month. Enter in the code SUMMER11 at checkout. It'll take 10% off everything, and it's pretty quick to ship. However, do not buy the pajamas on the website because they're out of stock, and for some reason I've removed them and they're still there. So I'm having to refund people. If you've ordered PJs, send me an email, gg@prettyliesandalibis.net. Give me your order number and I will shoot you a refund because they are not even being made anymore. So I don't want anybody to think I'm taking your money and running without giving you what you bought. Music fact of the day: worst 5 songs ever recorded according to readers from Blender. Number 5, Ice Ice Baby by Vanilla Ice. Totally a ripoff of Under Pressure by David Bowie and Queen. Number 4, Limp Bizkit Rollin'. Number 3, Wang Chung, Everybody Have Fun Tonight. Number 2, Billy Ray Cyrus with Achy Breaky Heart. Coming in at number 1, Jefferson Starship, We Built This City. All right, so let's get into George Wagner IV. If you've been on the podcast with me for a while, you know we covered this case when it was at trial. He was convicted last year of murdering 7 members of the Roden family and Hannah Hazel Gilley in one night with his dad and his brother. His mother assisted in the planning, the preparation, everything. They all 4 were arrested. A couple of years later, they nearly got away with it, but they were arrested and charged. His mother, Angela, and his brother, Jake, both confessed to their roles. In fact, Jake got up on the stand and without emotion, almost as if he's recalling a movie he's watched, tells how they did it. It was by far, I think, the most brazen crime I've ever covered on this podcast and maybe ever will. One night, they essentially wiped out 2 generations within a few hours. Very sad case. They did, however, leave the babies that were in bed with their mothers alive. Just an insane case if you really think about what they did. But George Wagner IV, who was convicted last year, he was just sent from Ohio to a maximum security prison in Rhode Island, which kind of has everybody wondering what's up. These transfers happen for a ton of different reasons, which could include health concerns, being targeted by other inmates, or if a certain facility is better equipped at handling the security, somebody with the notoriety he has would need to be safe. They're just not saying why. Very tight-lipped. His dad, Billy Wagner, is the last of the 4 family members yet to stand trial. He's pled not guilty and doesn't have a date set as far as I know, but I have heard early 2024. I really hope Law and Crime might send me out to that one. Or maybe me and Anjanette can tag team it. She's pretty local to the case. I definitely want to be there when Jake testifies this time. I heard it was very, very chilling to hear him talk about killing the mother of his daughter as if it's nothing. All right, so let's get into these Bryan Kohberger filings. And essentially, this all boils down to the DNA found on that knife sheath that was found underneath the body of Maddie and in between her body and the comforter, and how they were able to build a family tree, which led them to Pennsylvania, where they went into the trash and found that the suspect, their person they were looking for in the murders of Ethan, Maddie, Kaylee, and Xana, by using ancestry websites where people submit their DNA to look at their heritage, and they were able to build a family tree that eventually led to Khberger. And the defense is fighting this to the nail because DNA evidence is pretty solid evidence. It's very hard to explain how his fingerprint was on a knife sheath underneath one of 4 victims. So, but they're doing their job and they're trying. But this was an objection to the state's motion for a protective order. And what the state wanted to do or actually what they didn't want to do, is release information regarding investigative genetic genealogy used in the case to Bryan's defense team. In their filing, prosecutors said investigators found DNA of a potential suspect at the crime scene, and the FBI submitted the DNA to one or more publicly available genetic genealogy services to determine potential relatives of the suspect. This is relatively new in investigations, but it's becoming a way to lead law enforcement to suspects. This is not the first case this has happened in, and there have been successful prosecutions due to sites like Ancestry or these databases of DNA where you go in there and you get your results and it shows you who your relatives are. The FBI used the common genealogical techniques to develop a family tree, which led to Bryan Kohberger. The state seeks to protect from disclosure the names and personal information of the hundreds of innocent relatives on the family tree, the names of the publicly available genetic genealogy services used, and certain other information described below. The disclosure of this information is not required by Rule 16 of the Idaho Criminal Rules and should be protected from disclosure for the good cause described below, including the state's privilege to protect the identity of informers as described in Idaho Rule of Evidence 509. They explain finding the sheath. They go through kind of just the facts of the case, which is getting the 911 call and then finding this sheath. They ran it in CODIS and no match was found. Remember, CODIS is kind of a national database where when someone is brought in for a felony, they do buccal swabs or get DNA from them. That's entered into a nationwide database that law enforcement can tap into to see if perhaps the suspect is a known criminal or not. In this case, nothing came up. That's what prompted law enforcement to use investigative genetic genealogy to find a lead. It involves sending DNA to Ancestry.com or 23andMe. Then they compare the profile to the ones submitted to the service by others to determine ancestors and possible relatives. They say that law enforcement applies traditional investigative and genealogical methods to build a family tree to narrow down a potential suspect based on factors such as age, gender, opportunity, characteristics of the subject, etc. When my grandmother did it, I have a kit. I haven't done it yet, and I'm going to do it because if anybody in my family is exposed as being a criminal or somebody who did something really bad, too bad. Like, pay the price. I'm going to see where my ancestors came from. But on my grandmother's, it told, based on her DNA, what her physical characteristics would possibly be. It was right on track. I mean, it was amazing what they can find with those. They used a private lab to develop a lead to the individual who left DNA on that knife sheath. Once the FBI decided to take over the testing, the private lab stopped their work and their SMP profile was sent to the FBI. The FBI used the same tools and techniques used by the public who want to learn more about their ancestry. So they just started doing what a lot of us do, which is we log on there, send in our DNA and see we may have relatives all over the world and not even know it. The FBI found a family tree that contained the name, birth date, and death date, if applicable, of hundreds of relatives, as well as their connections between each other and Bryan Kohberger. The FBI sent local law enforcement a tip saying you might want to investigate Bryan Kohberger. It pointed law enforcement towards Khberger, but it did not provide law enforcement with major evidence of guilt. The items recovered from the trash at the family residence up in Pennsylvania when he was there over Christmas break showed the DNA in the trash belonged to the biological father of the individual who left DNA on the knife sheath. Get this, it was 5.37 octillion times more likely to be seen if Khberger is the source than if an unrelated, randomly selected stranger is the source. This is why they're fighting it, because this is kind of a slam dunk for the state. You've got his DNA underneath the victim on the very thing that held the weapon that killed all four of these beautiful, innocent college students. It says the information relied on by the FBI was only viewed through the portal in the publicly available genetic genealogy service and other investigative databases. The FBI did not download or create copies of those records. Once Khberger was in custody, the FBI removed the S&P profile from the genealogy service, which in turn, the FBI no longer has access to view much of the information that it used to create that family tree and cannot view it again without resubmitting the S&P to the website. To the state's knowledge, the only records that reflect the FBI's efforts to create defendant's family tree is the family tree itself, notes that were jotted down by FBI agents as they constructed that family tree, and any records created to document the removal of the S&P profile from the service pursuant to the Department of Justice policy. The state has not seen, nor does it possess these records or copies of these records. Then they go on to say the Idaho Criminal Rule 16 governs discovery in criminal proceedings, but it's not a free-for-all. As relevant here, the rule contemplates the state will provide 3 discrete categories of information: any material or information that would tend to negate the guilt of the accused, any documents or objects that are material to the preparation of the defense, intended for use by the prosecutor as evidence at trial, or were obtained from the defendant or belonging to the defendant, and reports of scientific tests or experiments. It says the defendant can seek a court order where they show a substantial need for the information in preparation of his case. The state seeks to protect the raw data related to the S&P profile and the underlying lab documentation related to the development of the profile, such as chain of custody forms, lab standard operating procedures, analyst notes, etc. All information related to IGG's efforts in creating a family tree and identifying the defendant's potential relatives, the identity of the genealogy service, and personally identifying information of the defendant's relatives. They will or have disclosed a genotype kit report from the private lab which documents a DNA test was performed. Information related to STR DNA analysis was conducted using the DNA recovered from the knife sheath and then DNA recovered from the defendant's parents' trash. Information related to the STR DNA analysis using DNA from the knife sheath and the DNA recovered from the defendant's buccal swab. So after he was arrested, they do the inside the cheek swab and compared it. And that's why we're here. We have a match, among other things. Now, the thing to remember is this DNA is part of what they have against Bryan Kohberger. It can be a slam dunk, but sometimes you don't necessarily need forensics for a case to be a slam dunk. There can be text messages that are incriminating. We just saw in the Lori Vallow trial, the only physical evidence tying her to the body of any of her kids was a single strand of hair that was found inside the bags her adopted son JJ was wrapped in. And one juror spoke out and said that really didn't matter to them because she lived with him. So you can see how sometimes in cases, DNA may look like a slam dunk, but really to the jury, it's not a huge deal. I think in this case, it's a really big deal because you have his DNA underneath a dead body. We're going to get into the defense side of things. They give a factual background about the 911 call and where Madison, Kaylee, Xana, and Ethan were found murdered. Law enforcement later found a Khber knife sheath placed next to Miss Mogen on her bed. The sheath was found buttoned side down and partially under Miss Mogen and the comforter. On November 20th of 2022, the Idaho State Police Lab in Meridian, Idaho, located DNA on the button of the sheath and performed STR analysis that led nowhere when ran through CODIS, other than to show the provider was a male. STR is short tandem repeat analysis. I did a little research on this, and let's just make a long story short. Using DNA to distinguish between two people is super tricky, because close to 99.9% of our DNA is the same as any random person on the street. I think we share a lot of DNA with a banana, if I'm not mistaken. It's a method of determining an individual's DNA profile by counting the number of times a small DNA sequence, which is called a short tandem repeat unit, is repeated at a specific chromosomal location. It's a gold standard method for accurate sizing of repeat expansions. And forensic DNA profiling utilizes autosomal short tandem repeat markers, which is that STR, to establish identity of missing persons, confirm family relations, and link persons of interest to crime scenes. So it's not like this is uncharted territory. This has been used a lot, especially since obviously all these ancestry sites popped up and anybody can spit in a tube. And then depending on which one you choose, it's out there for the public. Are you tired of choosing between taking care of your skin and wearing makeup? I find that most cosmetics have ingredients that make my skin dry, or that most clean makeup just doesn't do what I hope it would. I'm really, really glad I found Kosas. I love Revealer Concealer because it's packed with active skincare ingredients, and it offers creaseless medium coverage with a smooth, radiant finish that looks like your skin, just brighter, more even, and healthier. Take the 5-step Shade Finder quiz to find out your perfect match. My current favorite is the Glow IV Vitamin Infused Skin Illuminating Enhancer. I can skip using highlighter because it's in the makeup. So don't choose between wearing great makeup and taking care of your skin. Right now, Kosas is offering my listeners 15% off your first purchase of $50 or more when you go to kosas.com/whattheworld. Go to Kosas, KOSAS.com/whattheworld for 15% off your first purchase of $50 or more plus free shipping. That's kosas.com/whattheworld. By December 17th, 2022, lab analysts were aware of 2 additional males' DNA within the house where the deceased were located, and another unknown male DNA on a glove found outside the residence on November 20th of 2022. To this date, the defendant is unaware of what sort of testing, if any, was conducted on these samples other than the STR DNA profiles. Further, these 3 different distinct male DNA profiles were not identified through CODIS, leading to the conclusion that the profile does not belong to Mr. Khberger. Here's the thing. That was a party house. They had parties, as many college kids do. We've heard neighbors say frequent parties, lots of people. It's not out of the realm of possibility. They're going to find some unknown male DNA in that house and around the house. But I bet you ain't going to find it underneath a dead body. But I'm not a lawyer, just my 2 cents. I look at things like a juror. If I'm a juror, that's what's going to stick out to me. I don't care that there's DNA they haven't identified, but you got his DNA underneath the body. Come on. While this was ongoing, police were investigating various possible suspects. Many of them provided DNA willingly. At least one had his DNA taken from a discarded cigarette. Many also had their phones taken and downloaded. One area of the investigation had to do with a white sedan seen on a camera located at 1112 King Road, first glimpsed by officers on November 18th of 2022. By November 25th, police believed the car to be a white Elantra and asked law enforcement to be on the lookout for one. Precisely how the police came to believe the car was an Elantra is still unknown. A report from an FBI analyst for the FBI dated March 21st, 2023 shows the analyst heavily relying on a video of a car heading in the wrong direction and at the wrong time on Ridge Road. The state's filing admit that somewhere within all this, they engaged in investigative genetic genealogy, using the DNA taken from the button on the sheath, and now claim it was due to the use of this technique that it tipped local law enforcement to investigate Mr. Khberger. It remains unclear what the police first relied on in focusing their investigation on Mr. Khberger. No matter what came first, the car or the genetic genealogy, the investigation has provided little. There's no connection between Mr. Khberger and the victims. There's no explanation for the total lack of DNA evidence from the victims in Mr. Khberger's apartment, office, home, or vehicle. One thing to remember, the murders happened on November the 13th, and Bryan wasn't arrested until December 29th. Not only that, he was taking courses in criminal justice and was getting his PhD. He's not stupid in how to cover up a crime. He had over a month to get rid of any and all DNA evidence in his apartment, and I'm still not convinced that they didn't find anything. In essence, through the lack of disclosure and their motion to protect the genetic genealogy investigation, the state is hiding its entire case. So let's get into their argument. This is Bryan Kohberger's attorney's argument. The state apparently thinks they need not explain how they came to think it was Mr. Khberger's DNA on the sheath. Presumably, the defense is expected to accept at face value that the sheath had touch DNA just waiting for testing by all the FBI's large number of resources. Additionally, the defense is to guess whether the state focused its investigation on Mr. Khberger via a bizarrely complex DNA tree experiment or through its faulty identification of the vehicle involved in the case. Perhaps unsurprisingly, Mr. Khberger does not accept that his defense does not need this information. It rather obviously falls within the Rule 16b 4 and 5, a fact the state's briefing makes clear in its kitchen sink approach to their briefings. The state begins their argument claiming Rule 16 has no interest in IgG testing, and then ends their argument claiming that somehow people will stop sharing their genetics if they realize the government is watching. Both arguments must fail. I looked up these different rules, and it's a mandatory disclosure of evidence and material by the prosecution. That's A. Part B is the disclosure of evidence and materials by the prosecution on written request. And number 5, reports of examinations and tests. It says on written request of the defendant, the prosecuting attorney must permit the defendant to inspect and copy any results or reports of physical or mental examinations and of scientific tests or experiments making connection with the particular case that are in the possession, custody, or control of the prosecuting attorney, or the existence of which is known or is available to the prosecuting attorney by the exercise of due diligence. To begin with, the state apparently only wants to prevent Mr. Khberger from seeing how the IgG profile was created and how many other people the FBI chose to ignore during their investigation. In essence, the state argues that if the later STR testing is accurate, then there is no reason to concern ourselves with how the state came to investigate Mr. Khberger. The state's brief at 9. What the state's argument asks this court and Mr. Khberger to assume that the DNA on the sheath was placed there by Mr. Khberger and not someone else during an investigation that spans hundreds of members of law enforcement and apparently at least one lab the state refuses to name. See, this is really like trying to wiggle out of a wet paper bag. You've got DNA under a victim. It didn't come after the murders. This is a very steep hill for Bryan Kohberger's defense to climb up. But look, everybody's entitled to a defense. But to say that ancestral DNA isn't relevant in court and that doesn't lead you to the suspect, or that's not the way you should be led to a suspect, it's 2023. There are many other things out there, and good grief, look at the number of cold cases that have been solved in the last year or two using this very method. If it gets a dangerous person off the street, who cares how they got it? Perhaps the most puzzling is the state's argument that while Rule 16 A and B requires them to turn over the results or reports from scientific investigations, it does not require the state to disclose what law enforcement does with the results or reports. State's brief at 14. First of all, that sounds like an admission that the information on how the IgG was carried out should be disclosed. Second, what law enforcement does with results or reports is covered by Rule 16b 6, which says on written request of the defendant, the prosecuting attorney must furnish to the defendant a written list of the names and addresses of all persons having knowledge of relevant facts who may be called by the state as witnesses at the trial. The prosecuting attorney must also furnish on written request the statements made by the prosecution witnesses or prospective prosecution witnesses to the prosecuting attorney or the prosecuting attorney's agents, or to any official involved in the investigation of the case unless a protective order is issued as provided in the subsection of this rule. Also, on written request of the defendant, the prosecuting attorney must furnish to the defendant reports and memoranda in possession of the prosecuting attorney that were made by a police officer or investigator in connection with the investigation or prosecution of the case. Frankly, the fact that the members of the FBI were so concerned about permitting Mr. Khberger to know what they were up to with what was supposedly his DNA does not give the impression that there is nothing to see here, as the state seems to imply. Idaho Criminal Rule 16G2, prosecution information not subject to disclosure. Disclosure must not be required of an informant's identity unless the informant is to be produced as a witness at a hearing or trial subject to any protective order under the subsection of this rule or a disclosure order under subsection B6 of this rule. Finally, the state's claim that Idaho Criminal Rule 16G2 applies to this matter is quite bizarre. Presumably, the independent company the government relied on was paid for its work and would stand by it in a court of law. The state provided no real argument as to why the company needs to be protected. Mr. Khberger is left to suspect they wish to keep their methods from being questioned to the extent that there is some concern about intellectual property that can be addressed via a protective order that permits Mr. Khberger and his defense team to review their work. Second, the state appears to argue that everyone living on Earth provides genetic information, is unaware their DNA could be used by government somewhere for something, and is an informant within the meaning of the term in the rule. The state citations to cases involving actual informants hardly help it make this an incredible leap. No court has ever found the existence of a DNA informant. It would appear the state is acknowledging the companies are providing personal information to the state, and those companies and the government would suffer if the public were to realize it. The only two databases that allow access are ones that already inform their users, and those users can opt out to allow law enforcement searches. Okay, so can we just save all this and just blame whatever relative distantly of Khberger's uploaded and didn't opt out instead of blaming the state? The statement by the government implies that the databases searched may be the ones law enforcement is specifically barred from, which explains why they do not want to disclose their methods. If the fact that the government is looking at the genetic information that people are sharing was at all an issue, then the state's very public acknowledgement of such investigation is clearly a big mistake. In any case, it's hard to understand why Mr. Khberger should be the one to suffer, because these companies and our government choose either to mislead or not educate the public. According to the Pew Research Center in February of 2020, 48% of respondents thought it was acceptable to give their data to law enforcement to solve crimes. 33% said no, and 18% were unsure. However, 60% thought their genetic information could not be shared with other companies. There is no federal law about sharing of genetic information, but multiple states have begun regulating police use. Mr. Khberger has reasons to be extremely suspicious of the IgG used in this case. Rather than seeing it as some sort of complex tree building that led to him, it appears far more likely like a lineup where the government was already aware of who they wanted to target. Rather than have the investigation done by someone blind to that fact, the FBI chose to do it themselves. This is akin to the police pulling Mr. Khberger and 5 of his cousins off the street and then pointing at him. I don't know about you guys. I kind of think this is a really, really weak argument, throwing a bunch of stuff at the wall and seeing if anything sticks, because they don't want this DNA coming in. I mean, this is a huge, huge part of the state's case, and the defense knows that. Juries love forensics. They like to be able to say this person's DNA was found at the crime scene. But we just talked about with Vallow, didn't even really come into their conversation too much. They were able to connect the dots with common sense and text messages and just how it all unfolded. No DNA other than that hair strand. And look, in a case this big, I can guarantee you this DNA is not the only thing they have on Bryan Kohberger. A lot of stuff has been sealed. And I was super surprised this came out. But if you guys think that the DNA is all they have, just buckle up, because there's going to be much more that's going to come out that's going to incriminate Bryan Kohberger, in my opinion. I'm just saying. The authority the state has in its favor is on point, is a trial court order from a California case that settled before it could lead anywhere. It was a People versus Johnson case where the court in Johnson was not deciding whether a defendant had a right to know how he was identified, only that his identification could come in at trial without a mini trial about it. They talk about the state versus Ortega, where an appellate court heard similar arguments about the need for software used for facial recognition to be discovered to the defendant, though they would not be admitted at trial. We are keenly aware the cases we have discussed involve instances concerning potential expert testimony, and that here, we are dealing instead with eyewitnesses who have already identified the perpetrator, and the identification was found admissible under Wade. However, the facts of this case convince us the defendant will be deprived of due process if he does not have access to the raw materials integral to the building of an effective defense. The evidence sought here is directly tied to the defense's ability to test the reliability of the facial recognition technology. As such, it's vital to impeach the witness's identification, challenge the state's investigation, create reasonable doubt, and demonstrate third-party guilt. The FRT's reliability has obvious implications for the accuracy of the identification process, because an array constructed around mistaken potential matches would leave the witness with no actual perpetrator to choose. The reliability of the technology bears direct relevance to the quality and thoroughness of the broader criminal investigation, and whether the potential matches the software returned yielded any other viable alternative suspects to establish third-party guilt. The defendant's request for the identity, design, specification, and operation of the program or programs used for analysis, and the database or databases used for comparison are relevant to FRT's reliability. At trial, the state will likely have the investigating officer explain the police investigation, including the process of retrieving the still photo from the surveillance cameras ultimately used to generate an image of the defendant. Although we do not speculate regarding the exact nature of this testimony and whether defendant will seek to impeach it, the fact the state does not bear the burden of adducing testimony regarding the composition of the photo array does not bar the defense access to the discovery sought. Mr. Khberger finds himself in similar position as Mr. Ortega. Massive investigations came to focus on him and him alone. The state appears to be trying to hide its original domino such that he cannot discover why Mr. Khberger has the right to discover and question the investigation that led to him. This court should so find. So there you go. It's a little bit of a word salad for all of us non-legal people, but the point is this. They're trying any way they can to keep this DNA out because it's whatever they have that we don't know about. This is kind of your final nail in the coffin when you have the defendant's DNA underneath a dead body. So, of course, they're going to fight it. Don't know that they'll be very successful in it, but they have to try because that's their job. All right, so next week, Corey Richens, we're going to pick back up on that. It's going to take a while, I think, to go to trial, but this is such an interesting case, very tragic case. Poor Eric had no clue that she really was going to kill him. I had read, a lot of people had asked me, why did he stay after finding out about all the money she took? And also with the suspicion that she might have been poisoning him before she succeeded in allegedly killing him. is that he stayed for his boys. Now, mind you, she had life insurance policies on their 3 sons, which is terrifying considering she had policies on Eric. He was unaware of that she cashed in after he died. All right, guys. Hope you guys have a good rest of your weekend. I will see you Monday. Have a good one.